Hello, everyone. This is Haley Hansen. I'm the leader of Husch Blackwell's Higher Education Group. We're excited to give you today's presentation, Spotlight on Admissions, Legal Considerations, Do's and Don'ts. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, you'll see multiple application icons for your use during today's program. If you have any questions during the webinar, please submit via the question box. We will try to answer the questions during the webinar, but if a fuller answer is needed or if we run out of time, we will send you a follow-up email after the webinar. We do truly appreciate audience participation and encourage you to submit your questions. If you have any technical difficulties, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon, and we really encourage you to go to that icon and download the materials. We think it'll be very helpful for you, and some of them, as we're going through today, you may want to get a closer look on or take a little bit more time with. The program has been approved for continuing legal education credit in Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, and Texas. Wisconsin credit is still pending. To report your Illinois, Indiana, Nebraska, Tennessee, Texas hours, please click on the CLE icon at the bottom of your screen and complete the questions during the webinar. Also, a recording of today's webinar will be available tomorrow for your viewing and sharing amongst your colleagues at your colleges and universities. Once the link is emailed to you, you will also receive a certificate of attendance. This recording will be available for 2 weeks. Joining me today is Elizabeth Samples. Elizabeth serves higher educational institutions in various areas of compliance. She supports colleges and universities with day-to-day counseling. She leads our investigation team. She does training and policy work for a variety of our clients. She draws on her experience as a former attorney with the U.S. Department of Education Office for Civil Rights and works on a lot of compliance issues, including Title IX, the Americans with Disabilities Act, Section 504, and Title VI of the Civil Rights Act. We're happy to have you with us today, Elizabeth. So with that, I'm going to go ahead and jump into our topics that we're going to cover for today. And as you can tell, they're fairly lengthy. We are going to talk a little bit about admissions principles, give you an overview of the recent lawsuits and enforcement actions that we've seen, talk about program reviews and administration and misrepresentation claims. Elizabeth's going to walk you through early admission decisions and talk about permitted inquiries on admissions applications, diversity, privacy, and then we will end the webinar with some recommendations of how you can move forward. All right, so with that, we're going to start today with a poll question. Which of the following best describes admissions at your institution? Do you have open admissions? Do you have competitive admissions? Or are you implementing alternative standards, i.e. need blind admissions or test optional admissions? And Elizabeth, as we're getting some of our viewers to respond, I'll just ask you, we've kind of seen a trend of a lot of schools that have need blind admissions and are starting to move away from them based on budget concerns. What have you seen in that area as well?
I think that is an area recently that institutions are having to balance the benefits of having need-blind admissions in having more open and inclusive enrollment with financial considerations and constraints that they're facing. So we have seen a trend of institutions considering whether they can keep having need-blind admissions.
And again, there's so many pros for it, but it becomes very costly to the institutions as well. All right, well, we have about 60% of you who have responded now, so I will launch the results, and it looks like the majority of you have a competitive admissions process that are on the line. So that's good to know, but obviously there's a lot of differences in the types of admissions processes. So let's start at the basics, admissions principles. Admissions and admissions practices have been debated and discussed nationally for years. There have been several groups that say our admissions system is broken, and with the recent admissions scandal being brought to the forefront, this discussion is really getting a broader audience, and a lot of people are wondering, how do we fix this issue, and so how do we move forward? At the forefront, some affiliated groups that have been talking about this for a very long time are the American Association of Collegiate Registrars and Admissions Officers, and also the National Association of College Admission Counseling. So those two groups have really been keyed in on this as well. So, where does it begin? Obviously, admissions really, the overarching principle has to be that you have to have clear admission standards to make sure that the process adheres to the institution's stated policies about admissions, that there's no side doors into the institution, and that there may be institution admission standards or standards that are very specific to a specific program, especially when you have some programs that are highly competitive in nature to get into those programs. So we do recognize that there's a variety of admissions practices. There's not a one-size-fits-all. But I think the final bullet on this slide is the one that is most important to really take home as you're looking at where your admissions practices are and what you want to do in the future, and that's to make sure that your stated policies are what you're actually following. We see so many schools that get into these traps of their stated admissions practices they look at them as kind of guidance or something that they may follow, and that there's a lot of exceptions to those stated admissions practices, which can cause a lot of issues. And what types of issues can they cause? Obviously, legal actions. There are a lot of different types of individual and class action claims that are brought due to admission practices, fraud claims, discrimination, negligence, and I'm going to talk about a couple of these a little bit more in detail, and also contractual claims. We've seen a lot of government oversight, and especially with, obviously, the Department of Justice and the Department of Education, really looking at enforcement, and enforcement that's applicable to more than just the admission scandal that has been in the news the last several months. And also reputational harm, obviously, for prospective students and even donors, to make sure that you have that you are appropriately insulating yourself from any type of reputational harm. So let's talk about the recent college admissions scandal. So the Department of Justice refers to this as Operation Varsity Blues, the bribery scandal. And essentially, prosecutors have alleged that dozens of parents, test administrators, and college coaches were involved in widespread efforts to rig college admissions process for children of parents who are willing to pay bribes to get into particular competitive institutions. The indictments came down in the United States District Court for the District of Massachusetts, had hundreds of pages of allegations, and implicated more than 50 people in two sets of schemes. And the first is really the standardized cheating scheme, so sending another student to take a test, typically the ACT or SAT, in place of the student that is applying to college. That was the first kind of scheme that was put in place. And the second is bribery, and those kind of fall into two different categories. One of the larger categories are bribery for college coaches of students who were claiming to be on different teams that they never actually participated in high school, were not going to participate in college, but use that as a way to be admitted to the institution. And then the second is William or Rick Singer, who has already pled guilty, had two companies in which they were paying bribes in order to get students into, again, very competitive elite schools. So that's what Operation Varsity Blues is all about. What we are hearing is that this is the start for the Department of Justice, and that they actually already have subpoenas or document requests out to others in which they are looking at indictments as well. So there may be another round that we're going to see with the admissions scandal. So the resulting lawsuits, there were state and federal court cases against the institutions, and we're going to talk about that, and then also federal cases talking about racketeering, negligence, consumer protection violations, and unfair competition. So again, seeing a lot of litigation, and specifically with class action litigation, which I'm going to talk about as well, about others that were denied admission and not able to get in resulting from this unfair practice. So the question that, again, if you're not one of these 8 schools that has been part of this scandal is how does this really apply to your institution? What does this mean for all the other institutions, and how are we going to be assessed when you look at our admissions practices? And the first thing to really be aware of is negligence and what is being alleged. And what is being alleged is that institutions were negligent in failing to maintain adequate protocols and security measures to guarantee the admissions process was fair, and that it was fair to all applicants. So the suits accused the universities of being negligent and not having those protocols in place. So that's one of the big areas that we have seen as something that could be applicable to any school in terms of your appropriate admissions practices. The more likely to the vast majority of institutions is going to be enforcement by the Department of Education conducting audits for program integrity. And specifically, if you have a program review through your Title IV program, they are looking at whether or not you're meeting the program integrity standards. So in October 2010, the department published its final regulations that talked about program integrity regarding student financial aid. These regulations addressed 5 areas: institutional eligibility to participate in Title IV programs, recruiting and admissions was the second area that it addressed, eligibility to participate in particular programs that were being offered Title IV assistance, eligibility for disbursements and refunds as well in those particular programs that were getting those Title IV reimbursements. So when we look at kind of the depth and breadth of how this could affect your campus, we have seen that these program integrity and more specifically misrepresentations in the recruiting and admissions process are at the forefront of what people are really looking at for widespread admissions practices and making sure that it is fair. So this, as you know, sparked the Department of Education to investigate and do a preliminary investigation into those 8 institutions with respect to their administration of federal financial aid, really looking at how their admissions practices worked. And within those reviews, again, schools should be prepared to have a deeper dive into their admissions issues for program reviews. So as we've helped many schools with their program reviews, this has not been a particular area in which there's been a lot of time spent by program reviewers looking at admissions policies or practices, and we think that's really going to change. Elizabeth, do you want to weigh in on this as well?
Yeah, I do think that the department is either going to start using these program reviews to take a deeper dive into admissions, and certainly could be starting to refer the misrepresentation issues for oversight with respect to other agencies as well. So
yeah, I think it will continue to be something that is now really looked at, and it was to some extent not focused on as much by the department with the program reviews. And for those of you who haven't had a program review in the last 5 years, your school's name is likely on a list. Again, it may not get to you for several years, but for another program review. And so making sure that you have all your ducks in a row. This is especially important as well for those institutions that are admitting students through outside the brick and mortar admissions, and so online programs, making sure that your policies and procedures, that your standards are being upheld, and that you have all of those issues addressed, and that you're looking at those things through the lens of making sure that there are no misrepresentations, because that's been really a big issue for the department of complaints of types of misrepresentations to induce somebody to apply to your institution and to ask the student or the prospective student to provide money to the institution for that application fee as well. So making sure that there are no, what the department refers to as substantial misrepresentations. So any false or erroneous misleading statements, very broad definition of what is substantial misrepresentation. And essentially a misleading statement includes any statement that has the likelihood or tendency to deceive or confuse an individual, and a person could reasonably be expected to rely on that misrepresentation. So that's, I think, an important piece of the puzzle as you're looking at your own admission standards. So with misrepresentations, it's important that employees and even contractors are all following and taking the lead from your admissions office in terms of what you're going to say about your institution, what you're going to say about your program, that you're training those employees to have consistent conversations about to make sure there are no substantial misrepresentations that are made. All of those are going to be really important as you're looking at your overall admissions process and what the department expects for you to have in the overall admissions process. We saw a recent class action be filed within the last month against the University of Oklahoma, in which a group or a class of students said that there were misrepresentations made to increase the rankings of the U.S. News and World Report to have them go to those schools, and as a result of that, they were believe that there was a substantial misrepresentation. Obviously, the university, I think, will have some arguments that oppose those allegations, but it's something to be aware of, that now we're looking at all sorts of types of misrepresentation, and it relates to, a lot of you have heard about the borrower defense to repayment issues, which have been circulating in any compliance blogs or with lots of attorneys as well about what does this really mean from the department. The borrowers now may be eligible for forgiveness of federal student loans used to attend a school if the school misled them or engaged in misconduct in a violation of the law. And so now we are seeing students use the borrower defense to repayment to show where they have mailings or flyers or other types of marketing material in which there is a misrepresentation, and that may be about how many students get a job or are placed within 6 months after graduation, or what the salaries are going to be in those ranges. And so these are areas in which we're seeing increased activity, and students who are looking for misrepresentations to initiate the borrower eligibility for the forgiveness of their loan. So we're on to our next poll question. Institutions can provide incentive compensation for staff members based on successful enrollment numbers. True or false? So our first one was kind of just gauging our audience. The second one, the second poll question, will tease out your knowledge of whether or not you can provide incentive compensation to staff members for successful enrollments. We'll give the audience just a few seconds to respond. Okay, so now we are at, great, 87% of you say that this is false, and so that is absolutely correct. You may not provide incentive compensation to staff members for successful enrollments. In fact, this is part of the Higher Education Act through our regulations, which prohibits institutions from providing any commission, bonus, or other incentive directly or indirectly on the success of securing enrollments or financial aid to any person or entity engaged in student recruiting or admissions. And so it covers, it's very expansive. The employees covered by the incentive compensation band is really any person who engages in student recruitment or admissions activity or in making decisions regarding the award of Title IV or Title IV program funds. So it's very expansive in terms of lots of employees could be under that umbrella of who falls under the incentive comp. What types of compensation for employees does the band cover? It's really any type of commission, bonus, anything extra other than your salary. So if it's your regular salary or your hourly wage that you're receiving, anything extra that the employee will get, again, that is paid directly or indirectly based on securing enrollments will fall within this band. And it's been around, again, for many, many years. This was something, guidance that was put out in the Obama era, and now we've had those regulations in place for quite some time. But as we look at all the issues with admissions, there's a spotlight now on incentive comp again, which we really hadn't seen before. This was driven a lot under the Obama administration by the for-profit sector, and now we have seen a lot of not-for-profit institutions that also have had issues with incentive compensation, and so we're going to give you an example of that as well. One of the things that I wanted to just point out to you was a recent decision with the Department of Justice and Oral Roberts University to resolve incentive compensation charges. This was just on June 5th that this was reported. The university was accused of contracting with a now defunct outside company to help recruit students to its online programs and was paying the company a share of the revenue it received from enrollment and recruitment of students in violation of the incentive compensation ban. And so it is important to be aware of this, that again it affects all of us and we don't want to forget about it. Now the next two slides are really just breaking down a chart. The department has put a very useful chart together covering what are covered activities and exempt activities for incentive compensation, and so this is something I think would be appropriate for you to kind of look at in detail, but I'm not going to go through it, but it's again in the resource icon if you would like to download the slides. So finally, I want to talk a little bit about the legislative actions that we've seen since Operation Varsity Blues started, and that is first in California in May, there was legislation that was passed that students who don't meet the published requirements of an institution and are seeking an exception to those requirements can still be admitted, but require multiple approvals, kind of preventing this side door admission or ability for one individual to make that particular admission decision. We also saw the United States Senator Ron Wyden, hopefully I'm saying that correctly, of Oregon. He is the ranking Democrat on the Senate Finance Committee. He had a pledge to introduce legislation to respond to the issue of donors, because as we talked about before, we really talked about two large categories, cheating on standardized tests and bribery, and different categories within bribery, but those are the two. He's really targeting donors, that you have large donors who then their family member is admitted to the institution. And he wants this legislation, the Senator's legislation, would respond to that particular issue, and it would curb tax benefits unless the institution agreed, tax benefits for the donors, unless the institution agreed to implement policies prohibiting consideration of family donations as part of an admissions decision. So trying to separate the admissions decision from philanthropy or from donations to the foundation. And this bill has would make some changes through the Higher Education Act, and also would has had some people that think that this will be very detrimental to fundraising efforts at colleges and universities across the country, because as we know, that is a major way that colleges and universities are supporting their academic programs is through fundraising efforts. And so there's a lot of pushback on this bill as well. So we'll just have to wait and see if it gets any traction. So far, I'm not hearing it's getting a lot of traction so far. Elizabeth, are you kind of hearing the same?
Yes. Yeah, so far, it's just been recently that he introduced it, but we're hearing some pretty swift pushback, I think, against some entities who are concerned about the implications that this may have.
So with that, I'm going to turn it over to you, Elizabeth, and you can talk about early decision admissions and what that means for our colleges and universities.
Thank you, Haley. So yes, we'll spend the second half here talking about several admissions issues that, again, you all have been dealing with for many, many years, but we felt that using this kind of spotlight that's been on admissions lately would be a good opportunity to kind of talk through some of them from a compliance standpoint and some of the recent enforcement that we're seeing. So early decision admissions is, of course, a practice that has been used particularly to attract students to highly selective schools. It's a practice that has been criticized for favoring wealthy applicants. In fact, some schools have removed their early admissions decisions process, while some, like University of Virginia, had removed it but now are considering bringing it back in an effort to continue to increase enrollment and attract students. So the Justice Department has started an investigation into whether some colleges' early decision admissions programs violate federal antitrust laws. And this is primarily through agreements among the institutions. So the investigation is essentially about the sharing of information about these admitted applicants. So shedding light on what the department is investigating, the requests to colleges have directed them to provide information about agreements between institutions about disclosing the identities of admitted students. It includes communications with other colleges and universities about the transmission of this information, internal documents about what institutions will and will not communicate with other institutions, and then the communications themselves. And similarly, there was a recent case in which a student who was rejected from Yale School of Medicine alleged that the medical schools were sharing names of applicants and that this amounted to Sherman Act violations. The court dismissed the case and the application of the Sherman Act, stating that decisions by academic institutions about which and how many students will be admitted are non-commercial and therefore not covered by the Sherman Act. So this will definitely be an area to continue to monitor, especially if your institution operates early admission processes or is considering implementing or re-implementing one. So now I just want to spend a minute talking about international student admissions. There are, of course, typical requirements that apply to admitting international students. These include proof of sufficient funds, proof of secondary education completion, English language proficiency. One of the key compliance areas here is to ensure that the program requirements for the program for which the student is applying align with the student's visa terms. This comes up in situations of work and other academic placements and practicums. So the Student and Exchange Visitor Information System is used to provide oversight into the admissions and enrollment of international students. So, of course, institutions need to ensure compliance with CVIS reporting. For example, when a student first reports to the school, and then, of course, each semester upon continued enrollment. International student enrollment has been declining. There have been recent reports that have been released about this issue. So the National Science Foundation had a report earlier this year, and there was another report this month about a decline in international student enrollment. Recent reports have been citing the visa application process as a reason for this decline. Earlier this month, also, China's Ministry of Education warned students interested in studying in the U.S. about potential difficulties getting visas from the American government. So some are concerned that this decline will have an impact not only on individual institutions who rely on international student enrollment for their enrollment numbers, but also the overall competitiveness of graduate programs in the country. So now we'll move to our next poll question to transition into disability-related issues in admission. So in preparation for engaging in the interactive process for student accommodations, institutions can ask pre-admissions questions about disabilities. So we'll give it a minute to let participants submit their answers.
It's interesting to me. This is one that we get frequent questions about what can you ask,
right.
and what can't you ask. So I think it's a good poll question to see where our audience is at as well.
Okay, and so we have our responses. About close to 90% of you have indicated that this is false, that institutions cannot ask pre-admissions questions, and that is correct. With few limited exceptions, institutions cannot ask for information about disabilities on applications. This includes, the types of pre-admission inquiries you would typically think about, like your written application, other written materials, but also can include verbal discussions, pre-admissions meetings. And while I think sometimes there can be not a benign reason for asking these questions, we need to be careful because, of course, students cannot be denied admission because of a disability, assuming they meet the essential requirements or are otherwise qualified. And pre-admission inquiries about disabilities can lead to claims of discrimination. So some examples here of prohibited inquiries would be questions about alcohol or substance abuse. Questions should be limited to behavior or conduct and not necessarily to treatment or history with alcohol or drug abuse. Questions about whether or not the applicant has sought counseling or treatment for emotional or mental health problems would also be an example of a prohibited inquiry. And then asking applicants if he or she received accommodations on admissions tests. So there is an exception allowing for the voluntary identification of a disability in the pre-admission stage, but these are really applicable when an institution is actively engaged in affirmative action efforts, for example, to overcome prior limited participation of students with disabilities. And there are some important caveats when asking for this information even voluntarily. Institutions need to make sure that it's clear that the question is being asked because of these affirmative action efforts, and that the request is being, responses are being solicited on a voluntary basis, that the information will be kept confidential, and that the refusal to provide the information will not subject the applicant to any adverse treatment. A recent trend that we're seeing is students providing information about perhaps their own mental health history voluntarily upon application. So, to the extent that overcoming mental health challenges or other related challenges is significant to an individual's life, they may be providing that information in essay responses or in meetings with admissions counselors. And institutions need to be careful as that information is being provided even voluntarily to make sure that it is not being utilized or considered in a non-discriminatory way or in a discriminatory way. So at one institution recently, applicants who wrote about their own mental health in their applications were subjected to additional review, and in some cases they were rejected even if they were academically eligible. And so the institution went through an internal investigation and then decided that an external investigation was warranted to make sure that in engaging in these admissions processes that they were not discriminating against individuals on the basis of disability. So this really reiterates the need to set consistent practices for application review and to be particularly mindful of disability-related issues that may come up in the admissions processes as students share information about their past. And so now moving to criminal background and related issues. So most colleges and universities do not require prospective students to undergo criminal background checks, of course. Usually there's a middle ground that asks questions about criminal and disciplinary history. There may, though, be state law or affiliation agreements that do require pre-admission background checks, particularly for certain types of study, like nursing, medicine, pharmacy. Again, outside entities or state laws may require these background checks. In addition, institutions may alert students that they may be subjected to criminal background checks after admitted, either in connection with internships or before seeking licensure, for certain professional qualifications. So when it comes to this issue, you could envision, suits for denying admission, of course, to students based on criminal background check history, perhaps issues related to disparate impact theory. Alternatively, you could envision suits where a student is injured by another party and sues the institution because a background check was not completed to sort of to mitigate that risk. Courts have typically held that applicants do not have a procedural due process right in the application process and afford great deference to institutions about decisions, even when it comes to issues related to misconduct. Over time, courts have laid out constraints on institutions. Processes, for example, can't be arbitrary. They must abide by their published standards, of course, as Haley identified earlier. And so while there are cases where courts have upheld denying or revoking admissions based on criminal records, there is sort of a reasonableness standard that applies here. Courts uphold these decisions to revoke admissions, particularly where the information was not honestly disclosed initially to the institution. And the test basically analyzes several factors. Was the decision arbitrary? Was it consistent with standards of professional judgment? Is it reasonable in light of the severity of the crime and the truthfulness or lack of truthfulness of the applicant?
And that has been something, Elizabeth, that we've seen repeatedly, that asking those questions or having the affirmative duty on the student to disclose is really the best position that you can put the institution in, so that, again, if they are not truthful. But again, then you must decide then what you're going to do with that information. And if they have honestly disclosed and you're simply denying them based on criminal history, that can, again, as you pointed out, can have issues as well.
That's right. And then you have the knowledge of the potential past criminal behavior, and if something would occur, are in a position maybe to defend your decision about admission. So it is certainly an area where institutions need to be very cautious about the questions that they're asking and then what they're doing with the information when they receive it.
Well, and especially if you're going to go ahead and allow the student to enroll too, if it's a program or a course in which they have to take some sort of licensure exam, that they are enrolling or being admitted with knowledge that they may not be able to sit for we can't make, the school can't make any determination as to whether or not they're eligible to sit for a licensure exam based on a criminal background check. So those are also considerations as they're putting together their entire policies in this area.
That's right. And that's why even on an institutional basis, you may make one decision about these background checks, but on a programmatic basis, may determine that for those specific programs, something additional is more appropriate. And so while the Fair Credit Reporting Act does not apply in admissions, schools should consider sort of parallel procedural safeguards to help defend against decisions about admissions related to misconduct. And then finally, another issue that institutions want to consider is the jurisdiction or authority it wants to have over conduct that occurs after admission but before matriculation. So if a student is admitted but then engages in some kind of misconduct before they actually enroll in the institution, what authority do we want to have to take action with respect to that misconduct? And really this comes back to defining student in your student code of conduct and making sure that if you want to have sort of authority over that action, that you have defined student appropriately. This helps to ward against then complaints that an individual's admission was revoked inappropriately certainly if you can go back to the policy and tie the misconduct to the decision, the institution will be in a better position.
And Elizabeth, a question came in as you were talking as one of your bullet points, which is when the acceptance letter is sent in error, what's the best way to acknowledge or inform the student? I mean, and you have, again, acceptance letters that are sent in error, which does happen.
So in some of the higher profile examples of this, I think one of the best practices is to try to remediate the issue as quickly as possible. I mean, in some of the situations, the students were notified within an hour that the admissions letters, were sent in error. So really, this is a quality control issue. Making sure that we have clear quality control over how our admissions issues are communicated, and then if there is an error, really trying to fix it and acknowledge it as quickly as possible. Okay, so now on to our next poll question to shift topics to diversity in admissions. So to obtain a diverse student body, institutions may have race-conscious admissions practices. So we'll give you a minute to answer that question. And this is another area where, again, we recognize that you all have been grappling with this issue for years at your institutions and have been tracking high-profile cases as they have come through the courts. But to the extent that you're considering revisiting admissions practices across the board as a result of this spotlight or this area in particular, it's a good opportunity, we think, to go back and talk about some of the fundamentals. So we have about 2/3 of you have said yes, that institutions may have race-conscious admissions practices. And generally, this is true. Of course, we're going to talk about some caveats and particularly some state laws that may change that answer in your particular state. But yes, over the course of about 40 years, as a country through case law, we've been grappling with the issue of consideration of race in admissions. And overall, the fundamental principles are that the educational benefits from a diverse student body are considered a compelling interest. But in order to satisfy strict scrutiny, the means must be narrowly tailored. So the legal framework, of course, public institutions are subject to the Equal Protection Clause of the 14th Amendment, and then both public and private institutions that receive federal financial aid are subject to similar principles under Title VI. So the fundamental principle is that classifications based on race are suspect and therefore subject to strict scrutiny, and so that scrutiny is what has been applied by courts over the past 40 years and what has then resulted in different determinations about whether institutions have met that strict scrutiny standard. So the first case in 1978, Regents of University of California versus Bakke, this was the first case to articulate the view that the educational benefits of diversity could constitute a compelling interest. In this case, a white student challenged the university's practice of setting aside seats for students of underrepresented races. And while the court determined that the set-aside practice operated as a racial quota and was therefore impermissible, the court had a compromise opinion that ruled that schools could consider race as a +1 factor in a process that considered a number of different factors. And then fast forwarding to 2003, we had the companion cases, the Grutter and Gratz cases through the University of Michigan, one dealing with undergraduate admissions and the other dealing with law school admissions. So in the undergraduate case, the admissions system involved a point system that gave each underrepresented minority 20 points out of a possible 150. And the court found that it had the effect essentially of making race decisive for certain applicants and therefore was not permissible. In the law school case, however, the court upheld the admissions process because it included an individualized review of applicants that considered race and ethnicity among a variety of other factors. The dissent in Grutter really kind of highlighted what would come years later in Fisher, which is a focus on evidence of a consideration of race-neutral alternatives. And we'll talk about that here in a moment. So the main principles from Grutter, which are still, many of which are still in effect today, race cannot be rigidly applied as a factor. Applicants need to go and undergo an individualized, holistic review. The process cannot unduly disadvantage certain racial groups. The process should be reviewed periodically, and there should be a demonstration of a consideration of race-neutral alternatives. So the Fisher cases, more recently in 2013 and 2016, in Fisher 1, or both involved the University of Texas. In Fisher 1, the case was remanded for the lower court to apply strict scrutiny. And then when the case went back up in Fisher 2, the race-conscious admissions at UT was determined to be lawful. And we'll kind of just dig in quickly on the compelling interest and the narrow tailoring that was discussed in both of those cases. So some of the takeaways certainly from Fisher are that schools have to demonstrate institution-specific interest in having a diverse student body, and that these goals need to be clearly articulated so that the court can assess whether these policies and practices are designed to meet the goals. So a quote there from the case, a university's goals cannot be illusory or amorphous. They must be sufficiently measurable to permit judicial scrutiny of the policies adopted to reach them. So an institution really has to go through and define and determine what these benefits are that they are seeking of a diverse student body. And some of these can come from, various sorts of resources and certainly discussions and strategic discussions at your institutions. But Coleman has a roadmap to diversity and educational excellence, and some of these associated benefits are improved teaching and learning, support for workforce needs, eliminating racial and other stereotyping that pose barriers to inclusion, strengthening and assuring the legitimacy of civic engagement, and serving national security and economic interests. The key is, though, that while we can maybe look to research and experts about the benefits of diversity, institutions are really called upon under the Supreme Court standards to make specific determinations about their institution and define the goals for the institution and really be strategic about how it's going to meet them, particularly through narrow tailoring. So here, one of the main issues is to demonstrate that race-neutral attempts have been attempted but have not been successful in meeting the goals of the institution. So in Fisher, the court looked and determined that the University of Texas had a principled explanation for its decision to have the race-conscious admissions. There was a year-long study. They had looked at previous race-neutral policies that were ineffective. Before changing its policy, it had conducted months of study internally with stakeholders and really made a reasoned, principled decision about it. UT was also able to demonstrate that the other means of achieving these ends were not workable and had not resulted in the ends that they were hoping for. They had created new scholarships, they had opened new admission centers, they had increased their recruitment budget, and yet they were not achieving their goals. And so they were able to demonstrate the need for these race-conscious decisions. And then again, one of the key pieces is that these decisions and processes need to be periodically reviewed. So the court specifically said in Fisher that just because the policy was affirmed then did not mean that the institution could rely on it without refinement. So institutions need to set schedules, make plans for how often and when these types of admissions processes are going to be reviewed. So, of course, we have, in the past few years, a high-profile case against Harvard in which Asian American students have asserted that they were rejected because of an illegal quota system. The trial was held last fall. There's been a recent dispute about public release of some of the admissions records that have come out in discovery. So that is certainly a case that we're watching. There are also companion-related OCR investigations into Yale and Harvard's admissions practices. The Office for Civil Rights had previously had guidance that offered a roadmap under Fisher for how to legally consider race in admissions. That has been rescinded under the current administration. But again, there are examples of active OCR investigations, including Yale and Harvard. There was a 2015 OCR decision where OCR had reviewed Princeton's admissions decisions and found that there was insufficient evidence that the university discriminated against Asian Americans in their admissions processes. And their OCR looked at the holistic review process that the university was applying, and that they looked carefully at how applications were sorted and read and processed, and looked to see whether race was being considered impermissibly, and found that there was insufficient evidence that it was. Notably, in a recent OCR agreement in February of this year, OCR was investigating whether Texas Tech University Health Sciences Center, whether their admissions process that was race conscious could withstand strict scrutiny. And the institution engaged in a voluntary agreement with OCR whereby it committed to remove or discontinue the use of race in its holistic admissions process. And so in doing that, the university agreed to submit a memorandum to its admissions committee and other staff who are involved in admissions decisions, indicating that race will no longer be used or considered as a part of the admissions process. The university agreed to revise all of its admissions and recruitment materials to ensure that they did not include race as a factor. And of course, the institution also committed that if they choose at some point in the future to consider using race as a factor in admissions again, that they will make sure that that they have gone through some of the standards that we have just talked about with respect to Fisher. So as I mentioned earlier, your response to the poll question may have varied depending on what state you are in, because at least 10 states have passed laws limiting or banning affirmative action in public institutions. And so an example here is Washington State. So voters had barred public institutions from considering race in admissions, but now recent legislation has passed to reverse that ban that was voted on by members of the public. So this is certainly an area to keep watch on. We've seen, obviously some state law action, both with respect to, voting and then with state legislation in response. So again, some key takeaways. The goals for achieving diversity must be measurable, and institutions must have evidence to support the need for the race-conscious strategies. And so really this review, involves kind of going back and looking through what evidence would we have to demonstrate about how we made the decisions to implement these practices, and how can we demonstrate that we're carrying them out in a way that would survive strict scrutiny. And of course, periodically reviewing the means that we're using to achieve these goals. Okay, and our next poll question, our last poll question of the day, the Family Education Rights and Privacy Act applies during the admissions process. I'll give you a minute there. Okay. All right, so it looks like we have about a 50-50 split. So FERPA does not apply until an individual becomes a student, quote, student of the college. And so simply by applying for admission, the individual does not become a student. An individual becomes a student when attendance begins, and institutions are given discretion to determine when attendance begins as long as it's reasonable. So this could be the date that the student accepts the offer of admission, the enrollment date, the first day of classes, the first day that a student begins residency. All of these may be considered a reasonable definition of attendance. The key here is that institutions need to make sure that they have clearly defined that in their FERPA policy, so that individuals understand when FERPA applies to them as a student who is in attendance at the institution. Even absent FERPA, of course, admissions records can be disclosed at different times. They can be released and reviewed, whether that's based on a records request, through litigation. So, of course, the recommendation is to always be professional, even, in admissions notes. This is really a matter of training, of course, for admissions officers to really always make sure that there is the utmost professionalism and really making sure that we are documenting considerations that are permissible under our policies and under some of the legal principles that we've talked about today. In addition, institutions can reference admissions privacy policies with respect to their broader privacy policies. So this would be a commitment saying that institutions safeguard the privacy of personal data, and then refer back to the privacy policy stating that when individuals submit applications, that privacy policy applies.
So one point about FERPA and something that we've found in working with a lot of our institutions is that a lot of times they're not going back to make sure previous FERPA policies are taken down before the new version gets put up. And this is a big area in which we found a school who had 4 different versions of a FERPA policy available on their website. And in those 4 different versions, when a student when attendance begins under their FERPA policy was defined in 4 different ways. And so obviously if you get into litigation or anything like this, then the student is going to use the policy that's most advantageous to them. So make sure as part of your compliance work and things that you're doing over the summer as you're amending, you're improving your policies, make sure that the old versions are taken down, because all too often that is overlooked and has become a big issue for schools.
Mm-hmm. And I think too, Haley, the consistent description is also an issue with respect to what we're putting out about admissions. As we talked about earlier, when we're considering whether we're making misrepresentations about our admission standards and our admissions practices, we have also found that the descriptions of those can be varied across different pages of the website and different pages of handbooks. And so really making sure in that area as well that as you're going through and looking for consistency that your policies are aligned.
And really best practice has to be that there's somebody at an institutional level that's controlling that. If you give a website control and to post, there may be different policies that are needed for different programs, but it still should make sure that it's consistent with your overall institutional programs, because that's where we've really seen a lot of issues when it comes to those programmatic decisions and admission decisions and confusion, honestly, with students, and then that can lead to complaints either through the department or going further and looking for an attorney as well.
All right, so we'll conclude with a few final recommendations here. Of course, from a big picture standpoint, admission should be a part of any institution's strategic planning, and ensuring that administrators and staff are aware of the legal implications related to these admissions decisions is critical. Auditing current practices, we recommend that you, of course, first identify who at your institution is involved in admissions and recruiting, and be overly inclusive to make sure that you're including everyone that may have a role in this process. Identify, of course, who has oversight over the admissions decisions, including monitoring scholarships and financial aid. And then, as we just mentioned, reviewing applicable policies and not just the policies, but also your records. Kind of looking through recent admissions records to see what they can tell you about the application of your policies.
And one of the biggest areas that I've seen a lot of need for training, honestly, as a major recommendation is what our admissions representatives are writing down in our electronic databases with our applicants, and how much information and varied information is going in there, and what that could look like depending on what decisions you decide to make as well. So having some very clear, consistent training, and again, as Elizabeth said, making sure that they are keeping those comments very professional, but at times it seems to be a train of thought, and they're trying to get information so that they meet so many students that they can distinguish one from the other, which can cause some problems as well. So be very careful as to how you're training in those areas. So Elizabeth, I think we have time for just a couple questions before we get to the end. I just want to go back to, there were some questions that came in regarding incentive compensation, and one of the questions was if raises would violate incentive compensation. And the answer is no. An annual raise is not going to be a violation of incentive compensation for your admissions counselors or those individuals involved in admissions. And the percentage raises can be different based on their overall performance. What would be a violation is if you create an evaluation tool which only evaluates the performance of that individual on how many students enroll. That, again, if that's the only criteria and the only thing that you're looking at in evaluation, that would then violate the incentive compensation. It could be tied to, or could be equated to a violation there. Otherwise, that's not a problem when you look at incentive comp. So wanted to answer that question. And then another question came in when we were talking about criminal background checks, and I'll weigh in on this, and you can as well. So the question came in, are we given the advice that if someone discloses on an application that they have a criminal background, that you automatically deny the admission? And I don't think that's the advice we're giving. What we're wanting to make sure is that you have a consistent process as to how you're going to deal with that student, with their admission. And if it is in a situation where it's nursing, teaching, something where you need additional certification or the NCLEX pass rate, to pass the NCLEX exam, what we recommend is if you do admit that student, to have an agreement with that student and disclosure to the student that you are making no representations about their ability to sit in any state for any licensure exam, and that they are kind of, for a lack of a better word, assuming the risk of going through this program. You will have students that want to finish a nursing program but never sit for an NCLEX exam, never want to actually be a nurse but use that in some other way in their life. But as long as that's disclosed at the beginning, if you're going to enroll them, but we wouldn't want to have the situation, and obviously could lead to litigation, in which you admit that student and they believe that wasn't disclosed to them, and that their admission constituted an approval that their criminal background was fine for them to go into this particular profession. So proceed with caution is what I would say. No bright line rules, but make sure that you are working with your legal counsel to develop an appropriate criminal background check policy, and that typically those background check policies, when you have those disclosures or even hits on the background check, that there's some sort of process by which you're gathering additional information to make the best decision of whether or not the person should be admitted to that particular program. All right. Well, that's all the time we have. Elizabeth, thank you so much for all of your information. Thank you for joining our program today. We hope the information has been helpful to your institution. If you have not done so already, please click the survey icon, at the bottom of your screen and complete a short survey. Your feedback really assists us in deciding what our next programs are going to be. Again, as a reminder, continuing legal education credit has been approved in Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, and Texas. Wisconsin is still pending. A recording of this webinar will be available for you tomorrow for viewing and sharing. Thank you so much for your participation and for attending today.